Mr. McElroy, would you please come forward? Mr. McElroy, your full name is Aaron Jacob McElroy.
Correct.
How are you doing, Mr. McElroy? I'm doing fine. Thanks for asking. Mr. McElroy, I see that you were represented at one time by Mr. James Paget, and Mr. James Paget had filed a motion to withdraw. That motion was approved and signed on April 25th of 2023. Have you obtained another lawyer? Okay, why haven't you got another lawyer? Yeah, okay, now, Mr. McElroy, you have three options regarding your right to get an attorney. One option is you have a right to hire an attorney. Do you understand that option?
Yes, sir.
Second option is, if you can't afford to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option? And the third option is you can waive your right to an attorney, which means you can give up your right to have an attorney to represent you, and you can represent yourself. Do you understand that? Now, the court previously gave you a judge's explanation of rights to defendants without an attorney. And at that time, you wanted to hire an attorney, you hired Mr. Paget. Since then, Mr. Paget has withdrawn. And so the court is going to get you need to fill out another judge's explanation of rights to defendants without an attorney and make your choice. And then once you make your choice, then we'll proceed from there, okay? So just have a seat and the bailiff will give you a clipboard with that information on it and a pen. Is Jonathan Lee Cleveland present? Mr. Cleveland, would you please come forward? This is a motion to revoke probation. I might need to give him a copy of his motion. Okay, this is called.
Print it out, Trina, if you want to.
Okay.
I'll print the board.
This is cause number M327346. The case is styled the state of Texas versus Jonathan Lee Cleveland. Mr. Cleveland, is that your full name?
Yes, sir.
How are you doing, Mr. Cleveland?
Good. How are you, sir?
I'm doing fine. Thanks for asking. 1 minute, Mr. Cleveland. You've been summoned to court because there's a motion to revoke your probation
Yes, sir.
that has been filed by the Jefferson County District Attorney's Office.
I'm pulling up a copy so I can print it so you have it. Good.
Okay, yeah, I have one. Let me see.
For the show.
Yeah.
Yeah, I'm not giving
Yeah.
him a copy of it.
Really? I might be able to print it from here.
I can print it from here. I'm printing it right now, Judge.
Okay. He's written off a copy of this motion to revoke probation. I'm going to go over this motion with you before we go any further.
Yes, sir.
So it should be 2 pages on each copy. You have those, and then go together. This is the motion to revoke probation judge's document.
Okay,
Thank you.
now, Mr.
And
Cleveland,
the
I have
copies.
it right. Mr. Cleveland, the state has filed a motion to revoke your probation. In this motion, it alleges that you, Jonathan Lee Cleveland, on February 3rd of 2022, that you were tried for the offense of terroristic threat, family violence, which is a Class A misdemeanor. You were found guilty and your punishment was assessed at 180 days confinement in Jefferson County Jail, a fine of $1,000. But however, in accordance with the provisions of Article 4212 of the Code of Criminal Procedure, State of Texas, your confinement was probated for a period of 2 years, which means that you were placed on 2 years probation. In this motion, there are 5 allegations. Allegation number 1 alleged that you, Jonathan Lee Cleveland, failed to report to the Jefferson County Probation Office as ordered by the court for the months of September, October, November, and December of 2022, as directed in violation of condition 4 of your probation order. Allegation number 2 alleges that you, Jonathan Lee Cleveland, failed to pay court-assessed fees as ordered by the court. And as of December 20th of 2022, you were $1,232 in arrears in violation of condition 8 of your probation order. Allegation number 3 alleges that you, Jonathan Lee Cleveland, failed to immediately report to the probation office as your change of address, employment, marital status, or any arrest as ordered by the court in violation of condition 11 of your probation order. Allegation number 4 alleges that you, Jonathan Lee Cleveland, failed to perform the community service hours required as ordered by the court in violation of condition 14 of your probation order. And allegation number 5 alleges that you, Jonathan Lee Cleveland, failed to provide verification of entering and successfully completing an anger management program as ordered by the court in violation of condition 18 of your probation order. And Mr. Cleveland, if the court finds that any one of these allegations are true, your probation can be revoked. And if your probation is revoked, you can be sentenced up to 180 days confinement in the Jefferson County Jail. Now, as a defendant in a criminal case, could you give him that? He has a form that he's going to give you. I'm going to go over this form with you. It's the judge's explanation of rights of defendants without an attorney.
And you're on, I would like to hire you.
Okay. We're going to go over it.
Oh,
Give it. The bailiff is handing you a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You see that title?
yes, sir.
I'm going to go for this document with you.
Yes, sir.
And it reads as follows. As a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that option?
Yes, sir.
Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
And number 3, you may represent yourself. Do you understand that option?
Yes, sir.
If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. If you want to waive the right to an attorney, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states, defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney to represent yourself, then you will place your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you would date it today's date, August 20th of 2023. Do you understand?
Yes, sir.
Okay. Okay, Mr. Cleveland. I have before me a document that is titled Judge's Explanation of Right to Defendants Without an Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line
Yes,
as titled defendant? And are these your initials on the line that states, I want to reset this case to hire my own attorney?
Right.
Now, before you sign this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Cleveland, your case is going to be reset to give you an opportunity to hire your attorney. The court coordinator is going to reset your case. Once she resets your case, you'll be free to go and you have a blessed day. Please stand in front of the court coordinator.
Thank you, Your Honor.
You're welcome. Next case is cause number 23CCCR0660. Case is styled the state of Texas versus Christian Oliveras. Would you please come forward? For the record, your name is Christian Oliveras.
Yes, sir.
How you doing, Mr. Oliveras?
Good.
That's good, Mr. Oliveras. You're here with your attorney, Attorney Willard Hall. Attorney Hall, how are you doing?
Doing great, Your Honor. Thank you.
That's good. You're welcome. And the state is represented by Attorney Erica Porter. Ms. Porter, how are you doing?
I'm doing great.
Now, Mr. Hall, what is your announcement in Mr. Oliveras' case?
We request a 60-day reset. We have obtained the discovery, and I've been over it with Mr. Oliveras. I am talking to the district attorney's office, and he is working, and he is in compliance with the bond conditions. We have his receipt showing he received it unauthorized.
Okay. Okay. Let's see.
October 20.
I think I need to give him some bond conditions, so he's gonna have to come back about it.
Okay.
Okay, what's the date?
October 23rd or the 30th.
October 23rd or the 30th, which day?
30th.
Okay. It's okay, Mr. Oliveris, your case is reset to October 30th of 2023. And your attorney is gonna get your reset. Once you get your reset from your attorney, you're free to go. You have a blessed day. And Mr. Hall, this is your only case. You'll be free to go as well, and you have a blessed day.
Okay.
All right, you're welcome. Mr. let's see. Oh. Oh. This is. No, I'm Court is back in session and calls number M332458. The case is styled of State of Texas versus Aaron McElroy. Mr. McElroy, is that your full name?
Yes, sir.
Mr. McElroy, would you please raise your right hand? Mr. McElroy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. McElroy, you may put your hand down. Mr. McElroy, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Mr. McElroy, is this your signature on the line that is titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney? Now, Mr. McElroy, before you signed and initialed this document, did you read the document?
Yes, sir.
And did you understand what you read?
Yes,
Is everything in this document true and correct to the best of your knowledge? Mr. McElroy, your case is going to be reset to give you an opportunity to hire an attorney. The court coordinator is going to reset your case, but before she resets your case, you've been handed some bond conditions by the by the bailiff, and I'm going to go over these bond conditions with you. And it's titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
And it reads as follows: following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 and number 4 does not apply. However, condition number 5 does apply, and it's on the back page. Condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of the state agency or political subdivision.
Yes,
Do
sir.
you understand that?
Yes, sir.
Now, if you violate any one of these conditions, your bond will be revoked and a warrant will be issued for your arrest,
Yes, sir.
and you'll be placed in the Jefferson County Jail. Do you understand that?
I do.
Okay. Now, Mr. McElroy,
Yes, sir.
as stated earlier, the court coordinator is going to reset your case. Once your case is reset by the court coordinator, you'll be free to go, and you have a blessed day.
You too.
You're welcome. Okay.
Thank you, Dr. Abraham.
No, it's not bad. It's a-
Court is in session in cause number M 332-324, case style of state of Texas versus Kara Rochelle Partain. Ms. Partain, is that your full name? How are you doing, Ms. Partain? I'm doing fine. Thanks for asking, Ms. Partain. You're represented in your case. Well, your attorney of record is Attorney Bruce Smith. However, Attorney Smith is not here. However, standing in for Attorney Smith is Attorney Brennan Mitchell. Does Mr. Mitchell have your permission to stand in for Attorney Bruce Smith?
Yes.
Okay. And Mr. Mitchell, how are you doing?
I'm doing fantastic, Judge. How are you doing today?
I'm doing fine. And Ms. Porter, how are you doing
I'm
again?
doing
Mr. Mitchell, what is your announcement in Ms. Partain's case?
We'd ask the court for a jury trial, Judge.
Okay. Could you give us a date?
October 23rd.
Okay, this case will be reset for trial on October 23rd of 2023. Ms. Partain, your attorney, Mr. Mitchell, will get your reset. Once you get your reset from your attorney, you'll be free to go. You have a blessed day,
Thank
and
you.
thanks for the questions.
And Judge, I don't know what the prosecution know what it's gonna be. There'll be some motions forthcoming.
Okay, that's fine.
So it'll come through.
Yes. Jefferson County Court at Law number 2 is now in session. The court is in session in cause number M331664. Case is styled the state of Texas versus Emiliano Alcala Beltran. I have before me Mr. Beltran's attorney.
Roberto Salazar, Your Honor, my name. I'm an associate of Mr. Francisco Fernandez, the
Oh, okay.
attorney of record.
Okay, now, and let me see, how do you spell your name?
Roberto. Last name is Salazar.
Salazar. Salazar, Roberto Salazar. And Mr. Roberto Salazar, how are you doing?
Doing well, Your Honor.
And the state is represented in this case by Attorney Colby Hallpar. Attorney Hallpar, how are you doing?
Good, yeah, thank you.
Now, Attorney Salazar, I have before me a motion to release property that was filed on August 1st of 2023 by Attorney Francisco Fernandez. That's the attorney that you're standing in place of today. Is that correct?
That's correct, Your Honor.
Now, I mentioned to you earlier that I noticed here that on the motion to release property, there was not a section that you're using as authority to have this property released to you. However, pursuant to Article 17.17 of the Texas Code of Criminal Procedure, it states it's titled Disposition of Abandoned and or Unclaimed Property. And so are you proceeding under that particular statute?
Yes, Your Honor.
Okay, now, Mr. Salazar, you may go forward.
Yes, Your Honor. Our client was arrested in 2020, had, I believe, $4,924 seized from his person, part of his arrest, an investigation of the case. I believe approximately 2 months ago, cases that were pending before this court were disposed of. During the pendency of those cases, the state of Texas never initiated asset forfeiture procedures in order to gain ownership of that property, of that money that was seized from my client. And under the Texas Code of Criminal Procedure 17.17, we're respectfully asking this court sign this motion in order for my client to be able to receive that money back into his possession.
Okay, it's 18.17.
Or 18.17.
Yes. And state,
Your Honor, I've checked into this with our forfeiture division, and my understanding is the same understanding. I agree with counsel that the state no longer has, it's past the time for an asset forfeiture. We have no right to it, therefore we're unopposed to the motion for the property.
okay.
Property should be returned.
Now, the court is going to make some findings in this case.
Yes, Your Honor.
First of all, the court finds that there is unclaimed or abandoned personal property that is being held by the Beaumont Police Department. Is that correct?
Yes, Your Honor.
And the property that's being held is not held as evidence to be used in a pending case. As stated by counsel, in this case, cause number M331664, that case was disposed of on May 3rd of 2023. And the court finds that there has not been any evidence that show, well, there's evidence to show that that property has remained unclaimed for a period of 30 days. And the court also finds that there has not been any notice given to the defendant in this case regarding the unclaimed property, informing the defendant that, or the owner of the property, that he can claim the property within 90 days of such notice. No notice was ever given. Is that correct?
That is correct.
And so the court finds that the motion is timely filed because if the notice was given properly, the defendant would have had at least 120 days from the date of the disposition of the case to claim the property. And what I'm using is the 30 days that it went unclaimed, and then 90 days that the county purchasing aid, or not the county, the municipal court's purchasing agents was to give notice to the owner of the property that they had unclaimed property. And so therefore, this motion is timely filed within the 90-day, within the 120-day time period. The state is not opposed to the motion. And as far as we know, no other forfeiture action has taken place in this case. And so therefore the court finds that, or the court orders the release of the property in this case, which is $4,924 that was being held as evidence in cause number M331664, the case that was disposed of on May 3rd of 2023. Yes. And this is the order of the court.
Thank you, Your Honor.
Okay. Now,
We have a general order.
let me do this here. We can go off the record. Let me do this here. I noticed Jefferson County Court at law number 2 is back in session. The court is in session. The cause number 23 CCCR 0042. Case is styled the state of Texas versus Fred Farbett Vickers.
Yes,
Mr. Vickers, how are you doing?
doing great. Thank you.
That's good. Mr. Vickers, you're here represented by your attorney, Attorney Kevin Lane. Attorney Lane, how are you doing?
I'm fine, thank you.
Mr. Lane, what is your announcement in Mr. Vickers' case?
Your Honor, we've received all the discovery. I have seen all the discovery and the videos. We're asking for one more announcement.
Okay.
If I may,
Okay.
and sorry for being late over in drug court. That's
Okay. So how much time you need?
Just a regular announcement.
Give us a reset date. October 23rd or the 30th? Which
30th.
one? 30th?
I won't be trick or treating.
October 30th, is your reset date, Mr. Vickers?
Yes, sir.
Your attorney is going to get your reset here in court. Once you get the reset from your attorney, you'll be free to go. You have a blessed day. Thanks for being patient with us.
Thank you, Your Honor.
All right.
Thank you.
Already signed.
He's going to get it right here. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M332808. The case is styled the state of Texas versus Joseph David Loop. Mr. Loop, how are you doing? I'm doing fine. Thanks, Fax. Mr. Loop, you're represented in your case by your attorney Langston Adams, who's appearing via Zoom. Attorney
I'm here,
Adams, how are you?
Judge. I'm doing well, Judge.
Mr. Adams, what is your announcement in Mr. Loop's case?
Hey, on Mr. Luke's case, I'm still doing discovery on the case. Once I get all my discovery on it, I'll be ready to rock and roll.
Mr. Could you give us a reset date?
23rd or the 30th.
October 23rd or the 30th. Which date is best?
You said October the 3rd or the
No.
30th?
October 23rd or the 30th? Or October 30th?
Go with October 30th.
Okay, this case is going to be reset to October 30th. Mr. Luke, you're going to get your reset hearing in court. Once you get your reset, you're free to go. Thanks for being patient with us. And you have a blessed day, and stay in contact with your attorney and your boss.
Thank you.
All right. And Mr. Adams, your reset will be sent to you. You're also free to go, and you have a blessed day.
I think you gotta go back. Yeah.
Mr.
Thank you,
Adams,
Judge.
all right, you are.
Was able to do the plea, and that was from yesterday.
Okay.
Okay, and let me know. Because I would have had to move both of them.
Next case is Ms. Mayfield.
Okay, let me know.
The court is in session and calls number M333036, case of style of state of Texas versus Crystal Mayfield. Ms. Mayfield, is that your full name?
Yes.
How you doing, Ms. Mayfield? I'm doing fine. Thanks for asking. Ms. Mayfield, you're represented in your case by your attorney Benjamin Jeffries, who is appearing via Zoom. Attorney Jeffries, how are you doing?
I'm doing well, Your Honor. Thank you.
Mr. Jeffries, what is your announcement in Mrs. Mayfield's case?
We would request just a reset and allow me to go over the discovery and meet with Ms. Mayfield and discuss her case in detail and get an offer from the state.
Okay. How much time do you need?
1 month should be sufficient, 30 days, less.
23rd or the 30th.
Okay, now your case could be reset to October 23rd or the October 30th. Which one is convenient for you?
October 23rd is fine with me, Your Honor.
Okay, so this case is going to be.
You said October?
Yes, October 23rd or October 30th.
Yes, sir. Okay.
23rd.
Just wanted to make sure I
Okay.
heard right.
Okay, so this case will be reset to October 23rd. Ms. Mayfield, your attorney will be given notice, your attorney, your bonds will be given notice of your reset. And you will be given a copy of your reset here in court. Once you get a copy of your reset, you'll be free to go. Thanks for being patient with us, and you have a blessed day. Please stand in front of our court coordinator. And Mr. Jeffries, your reset will be sent to you. You are free to go. And thanks for being patient with us. You have a blessed day.
Yes, sir. Thank you, Your Honor.
Okay, you're welcome.